Okay, we are now live and on the record for Wednesday morning civil docket for March 30th, 2022. And I'm going to start with Mr. Ruiz. What number, sir?
Good morning, Your Honor. Number 20 on your docket.
All right, that's CL 173055-I, Mahdi, M-A-H-D-I, Shaheen, S-H-A-H-E-E-N versus South Texas Educational Technologies et al.
That is correct, Your Honor.
And what is your announcement, Counselor?
Your Honor, my announcement is that we are not ready to proceed with the plea to the jurisdiction that's been filed in this court. We were served with some documents, Your Honor, and I have not had an opportunity to speak with my counsel, with my client about those documents. And because I have to explain to him how this case is a 2017 case and it's been dragging for so long. And now there's a plea to the jurisdiction saying the court doesn't have jurisdiction. He's a smart guy, and I think he deserves an in-person meeting with me, which I really haven't had with clients up until after spring break. So I would like a little bit more time to address the issues in the plea to the jurisdiction, review the discovery with him, Your Honor.
Okay, Mr. Livesay?
Your Honor, the plea to the jurisdiction was filed the first day of December and of last year, and then the case, we had a status hearing, and you ordered me to get the discovery done. The discovery was filed the discovery answers were filed in the middle of February. So while I understand opposing counsel's desire, on the other hand, I've got a client who wants to get this, who is like saying, well, let's get this case moving and, do something. And so if the court, and obviously the court's got a busy docket today, so I don't think that it could hear the plea to the jurisdiction, but I would like a date certain to, for it to be heard. And essentially, this is it's a summary judgment type matter that they have to present enough evidence to overcome, the respective burdens on the McDonnell-Douglas factors in order for this to show that this court has jurisdiction. So I don't think it should be too terribly difficult to adjudicate or too terribly difficult to understand.
How much time do y'all think that you'll need for that? As far as court time, I mean, how much time do y'all need in order to argue your sides on that plea to the jurisdiction?
I
can't. 30 minutes. I would say 30 minutes from the plaintiff's perspective.
I was going to say 15 minutes from the defendant's perspective. It's a very easy fact scenario.
Okay, we'll do May 2nd at 11 a.m.
Thank you, Your Honor. I really appreciate the extra time, and may I be excused?
Yes, we'll be ready to go. You'll just be ready to go on that day. Mr. Livesay, do you have any other case?
No, Your Honor. Thank you.
All right, y'all have a good day.
Thank you.
All right, Mr. Vega, what do you have?
Number 4 on your docket.
F 2335-20-9 in the matter of the marriage of Guillermo Sanchez and Maria Montalvo.
Yes, Your Honor. Oscar for Mr. Sanchez, Judge. We started the final hearing and it came out that he was in custody. So I went down to go visit him. I'd like to put him on. He gave me a whole different story than what you heard the first time, that CPS was involved. She tried to burn down the house with the kids in it. And he's actually asking for a trial on his assault case that she's the victim, alleged victim on her. And so if we could get us for a date to where they can put him on, Judge, your jail docket, I guess.
Oh, okay. Yes.
And so I can also investigate the allegations. I know she has somewhat of a criminal history, but I can't find that one with a CPS.
Okay. And is Miss Sosa still on the other side?
Yes,
Your Honor, I'm here.
Okay. All right. So then you're asking for this to be set for a time when they can bring him. Is he still in custody here in Hidalgo County for sure?
For sure he is, because they made an issue of him. He was in Brooks and he made an issue of not being able to visit with his lawyer, so they have him here permanently.
Okay, so how much time are you requesting?
Judge, next week is fine. Just so we can put him on. My trial got canceled in federal court, so I think I'm going to be available next week.
Okay, I do have a jail docket on the 5th, on April 5th at 1:30.
Yes, Your Honor, perfect.
Okay, but we do have some criminal cases, so just be prepared to wait a little bit.
Yes, Your Honor.
Okay, so it'll be April 5th at 1:30.
That's all I have, Judge. May I be excused?
Yes, you may. Ms. Sosa, do you have anything else?
No, Your Honor, may I be excused?
Yes, you may.
Thank you.
Thank you. Okay, Ms. Tania,
Yes, good morning, Your Honor. I'm number 19 on the docket.
good morning. CL 220021-I Discover Bank versus Ed Snearley, SNEARLEY.
Yes, Your Honor, and it's Tania Olet for Discover. The plaintiff, this is just a motion for substituted service. It looks like our process server has been out to the house a few times, has confirmed that the defendant does live there, but they are not answering the door, responding. So we're just asking for a motion for substituted service to be granted.
Okay. And I do see that the proper affidavit is on file. So
Yes,
the
Your Honor.
court will take judicial notice of those documents in the court's file that that support your motion for substitution of service, and I'll grant it.
Thank you, Your Honor. That is all that I have. May I be excused?
You certainly may, ma'am.
Thanks. Have a great day.
Likewise. Mr. Sabo?
Good morning, Judge. I've got 3 status conferences and a hearing that I at 11 that I need to check on. The status conference number 20 and 31 on your docket, and the hearing is number 3.
Okay, I'm sorry, you broke up. So you froze.
I guess number 3 on your docket, the docket says 11 o'clock.
Yes,
Are we doing
yes.
that at 11?
yes.
Okay,
Unless you all are not having a contested hearing anymore.
it's contested.
Okay,
Okay, so we'll do that 11. Okay, the other 3 are number 28 with, I think I see Heather. There she is. She's on that one. Then I've got
Okay.
number 29 with Mr. Guajardo. I saw him earlier. And then 31 with Mr. Ariano.
okay, CL 196725-I Bernardo Trevino versus Eunice, EUNICE Marin.
Judge, it looks
Yes,
like,
Heather Brew on behalf of Bernardo Trevino. Yeah, go ahead, Frank. Sorry.
it looks like the plaintiffs added Allstate as a defendant to this lawsuit, and I don't see that Allstate has been served yet. So I guess we are kind of on hold until that happens, if I'm correct on that, Heather.
Yes, we did add the UM to this, and we're just, I believe, waiting for them to answer and get that served. So if we could just have a little more time to get that accomplished, I think we'll be ready to move forward soon.
Oh, okay, how much time? I mean, you still have to bring them in, and then are you going to be asking them to submit to participate in the discovery process as well, or what?
Yeah,
Okay,
right. So they'll need some discovery likely. So I would say we would need at least 90 days.
okay, June 27th at 9:30.
2-7.
June 27th? Yes,
Okay.
6/27 at 9:30.
Thank you.
Okay, Ms. Abreu, do you have another case?
I do.
Okay. Let me just finish with Mr. Sabo's statuses and then I'll take you up.
Okay.
Okay, CL1, is that all on that case?
Yes.
Yes.
Okay. CL 185513-I, Vilma, Vilma, Vanessa Torres versus Fabiola Munoz Dominguez.
Morning, Judge Raul Guajardo for the plaintiffs.
Judge, we're set for mediation on June 2nd.
Okay. Then just come back on June 27th at 9:30 on this one as well.
We'll do it.
Okay.
Hopefully we won't. Hopefully we'll settle and we won't, but
But
Well, that's
don't
what
have-
I'm hoping for too.
I was thinking of just filing a DCC, Your Honor, as well. Of course, hopefully we'll get it resolved, but
Yeah.
do I need
Well,
to?
let's just wait to see what happens at your mediation. You won't be set. I mean, we already have literally had probably over 100 DCCs filed, so you'll be like way down the line.
Okay, so,
So, it's okay. I mean, it's not gonna get you bumped up any sooner.
all right, Judge.
So go ahead and just go to the mediation and get it settled. But if not, you can do that later after that.
What, June, what again?
27th at 9:30.
Thank you, Your Honor. That's all I have. May I be excused?
You certainly may.
Thank you, Judge.
Okay, CL 21737-I, Juan Jose Alvarado versus Manuel Saavedra, Saavedra.
I haven't seen Mr. Ariano, but I haven't scrolled through all of my.
I saw Emerson.
Good morning, Your Honor.
There he is.
There we go. Judge, this one, we just need to set depositions and get that started. It just hasn't been done yet.
Okay, Mr. Arellano, do you have anything to add?
That, Your Honor, and I've heard you had 100 DCC, so we can also be sent to mediation, so we can get that done or get some type of scheduling.
We have, we'll do that. We've got some dates set aside for mediations that we'll get to Mr. Ariano and we will get that set. And
Okay, so more or less, what are you looking at for those depots in the mediation? What time frame?
probably the mediation's not until June or maybe even July, just because of scheduling.
Oh, okay.
Just because of availability. So if we could maybe come back in August-ish,
Sure.
maybe late July, August.
Okay. We'll do August 22nd.
9:30, right?
Yes.
Perfect.
Okay, anything else, Mr. Sabo?
That's all I have until 11 o'clock, Judge. I'll see you then. Thank you.
Okay, Mr. Arellano, did you have another case?
No, I don't, Your Honor. May I be excused?
Yes. Ms. Abreu, what was your next case?
30, Your Honor.
CL 200862-I, Luis Sustaita, Sustaita Jr. versus Felicia Rivera et al.
Yes, Your Honor. We are scheduled to mediate that case on April 8th, which will hopefully resolve that matter. So I guess we just need a date following that mediation.
Okay, is Mr. Denzer still on the other side?
I am,
As far
Judge.
as I'm sorry.
Yeah, we deposed Mr. Sustaita, and yeah, we're set for mediation, as Ms.
Okay.
Abreu said.
And so after you mediate, are you finished with your discovery process? Are you still taking depositions?
I believe we're complete with discovery at that point. We're all set.
Okay, so then May 2nd at 9:30, and let me know how it went.
Sounds good. Thank you, Your Honor.
Okay,
Thank you,
That,
Judge.
that is all I have today. May I be excused, Your Honor?
you certainly may.
Thank you. Have a good day.
You too. Mr. Denzer, did you have another case?
I have 3 other cases I'm covering for Guillermo Tijerina, but I'm not sure if the attorneys for the other side are on. I think Mr. Rick Garcia is, but I wasn't sure about the other attorneys.
Okay.
Do you want
what
to take
case-
those now, or do you want me to wait until the other people who had their hands up go?
Go ahead and wait to see that the other attorneys well, I saw Jared here.
Yeah, he's
So
one of them
Mr. Clark
too.
is here. Okay.
I'm here, Judge.
CL 202580-I, Diandra, Diandra Vargas et al. Versus Jackson Wright, WRIGHT.
Good morning, Your Honor. Jared Clark here for the plaintiff.
And Nick Denzer covering for Guillermo Tijerina for defendant, right?
Okay, and what is the announcement?
Well, we're here on status, Judge. The last time we met was back in February, and it was concerning a motion for stay filed by defendants. They're requesting a stay under a federal statute that has certain conditions that need to be met. One is they need a letter from their service member, basically stating how his military appointment prevents him from appearing in the case, and to state a date when he can appear. And then the second condition is that they need a communication or some type of letter from that service member's commanding officer, stating that the service member's current military duty prevents appearance and that the military leave is not authorized in order for the service member to appear. About 30 minutes ago, I was emailed what appears to be a letter from the service member's commanding officer in this case. And if with the court's permission, I'll share my screen so I can show the letter.
Okay,
Yeah,
Mr.
and Judge, that shows we didn't file with the court because it shows his duty location.
Oh,
So that's why we just sent it to opposing counsel rather than file it with the court at this time. We just got it this month.
right. If it has any personal information like that, when it comes to government officials or government workers, I don't make that public, Mr. Clark. So, but I'll go ahead and allow you to elaborate on your position with respect to that letter.
I appreciate that, Judge. So what the letter does, in a sense, is basically identify who the service member is and where he's serving. And it confirms that he is serving. Of course, what the letter lacks and what is required by the statute is a statement from the commanding officer that the service member's current military duty prevents appearance in the case, and that military leave is not authorized for the service member to appear. Those two very important conditions in the commanding officer's letter are not present. And so we don't think that this is sufficient to satisfy the conditions of the statute. And what bothers me a lot about the letter is I appreciate that the letter at least discloses the amount of time that this service member is expected to serve, which is it states that his expiration of active obligated service is August 9, 2025, which is over 3 years from now. And the frustration my client has is that her car is still damaged. It still has damage on it. State Farm has not offered to repair 100% of it. They're trying to assert some comparative fault on her. And she feels that this is because of what's going on here with the service member. She either accept what State Farm is offering you right now or wait 3 years. And so she's very frustrated with how the process has been going negotiation-wise with State Farm. And if State Farm is allowed to basically stay this case without satisfying the conditions of the statute, then she feels like she's sort of left in the dust. So the court had set this for status because the amount of time that they had requested in their initial motion requested a stay up until March 17. They've had that time, and we feel, since the last time that we met and up until March 17, and even today, they still have not complied with the requirements of the statute. And so we're asking this court to deny their motion for stay and allow our client to participate or allow our client to push this case forward, at least get some discovery done, and even written discovery. I mean, there's a lot that State Farm can do without even the participation of their own client. They can at least give us initial disclosures regarding how much insurance is available. There's a lot of stuff that they can answer even without their client's participation. So anyways, that's our position, Judge, and we ask that the motion be denied.
Okay, Mr. Denzer, your response?
Well, Judge, it was I thought this was just a status conference. So if Mr. Clark wants to argue the motion to abate again, I'd ask that be reset for a different date so Mr. T. Hadina can do it. This letter we got from the commanding officer of our client, it took some effort to get it. Basically, the Navy says, we don't care like about your deadlines and what you're filing. This is, you get stuff from us. When you get stuff from us, we're involved with Ukraine and we've got people moving around and all sorts of stuff. He's attached to a fighter squadron unit in California. I don't believe we were asking for a stay for 3 years. And Mr. Tihadina did tell me that we were able to talk to our client and get some information that we can be able to respond to discovery. So that's one of the issues we have sometimes when we're defending active duty service members. It's going through their superior officers, getting the stuff that we need, and if it's not correct, getting something else that that helps comply with statutes, like Mr. Clark was saying. So I think we have some information to be able to respond to some discovery. I don't know if we were still requesting a stay on this now that we've got some information, but we will need some
Okay. Well,
extra time for some things because of him being active duty.
Okay, so we're set for a status hearing today, and so fine, I've got my status, but what I'm going to ask is for you all to appear at my chambers on April 5th at 4 o'clock, and we're going to staff this. And April 5th, next Tuesday at 4 o'clock in my chambers, that's the 3rd floor. So whoever has authority to staff it needs to be present, okay?
Is that sorry, Judge, is that the new courthouse or the old courthouse?
Oh, no, the old one. The new one is,
I haven't been to the old courthouse for over a year, so I just wasn't sure.
yes, it's the old courthouse, 3rd floor. Yeah, the new courthouse is probably far, well, let me not say anything.
Is that,
I have
so
to
is that
remind
to
myself
discuss,
I'm on YouTube.
is that to discuss the any kind of abatement
Yes.
that, okay.
Well, we're gonna talk about some, yeah.
Okay.
We're gonna staff it and we're gonna come up with a resolution. Maybe not that both sides will be happy with, but you know, we need to, there are some things that I want to share with you all, but I think it's best said if you staff it.
Thank you, Judge.
I appreciate that, Judge. That's all I had before this court. May I be excused?
You certainly may.
Thank you, Judge.
Okay, what other case, Mr. Denzer?
I have one with Mr. Rick Garcia. It's number 27 on your docket, Cantu versus Garza.
Yes, I'm here, Your Honor. Morning.
Okay, good morning. CL 21-2583-I, Emilio Cantu et al. Versus Eliu Garza. What is the announcement, gentlemen?
This case was you had entered an order that we mediate this case back in December. Your Honor, I've spoken to Mr. Tejeda. He was in December, he was in the process of moving offices, and we weren't able to get it set due to the transition period that he was moving from one office to another and getting a staff set up. We've spoken, we're going to set this for mediation, Your Honor. We've spoken even as early as yesterday, so I can tell you that.
And then that's what I heard too, Judge, that it's being set up for mediation.
Okay, so any dates do you have a time frame for that?
No, he asked me to send him yesterday a demand, and then we would speak shortly thereafter. So I expect I'm gonna get my demand out today. I will speak with him within let's say 3 days, give the mail a chance to get there, and then we'll have a date.
Okay, let's come back on June 27th at 9:30. That should give you plenty of time. If you need a date sooner than that or it settles, just let us know.
Yes, ma'am. We
Okay.
have no further. Yes.
Thank you, Judge.
Okay, thank you. Y'all have a good day.
You too.
I have
Okay,
one more Oh, sorry.
Go ahead. Another case?
Number 23 on the docket, it's Mr. Tijerina's case, but I believe we settled out our portion. I don't know if the case still remains pending with the other defendant.
Okay, CL 190754-I, Brian Esparza versus Olga Calvo, CALVO et al.
Good morning, Judge. Danielle Rodriguez for the plaintiff, Brian Esparza.
Okay,
And Daniel Vargas is here for the other defendant.
Mr. Vargas, who is it that you represent, Jose Cortez or Ms. Calvo?
Cortez, Judge.
Okay. And what is the announcement?
Judge, we have settled fully with Olga Calvo. So Nick Denzer, his client's out of the case.
Okay.
So we are still proceeding against Mr. Vargas's client, Jose Cortez. We have mediated the case. At mediation, we settled with defendant Olga Calvo and we recessed as to Jose Cortez in order to give him time to obtain some further information that he was needing. And we are currently set for a DCC on April 8th.
Okay, so have you filed your non-suit or on Ms. Calvo yet?
Yes, Ms. Calvo was dismissed on February 11th of this year.
Okay. All right, so Mr. Denzer doesn't have anything to do with this anymore, Mr. Tijerina. Okay, so since you're already set for a DCC on April the 8th and your recess, is it that the mediator is going to try to help you see if maybe they can do a mediator's proposal or is it just that you all just, there's not going to be an opportunity to try to work it out?
It was my understanding that we were going to try to reschedule, resume the mediation. Mr. Vargas wanted to, I guess, further explore if there was actually insurance coverage that would apply in the case.
Okay, Mr. Vargas, is that your understanding that you will be rescheduling the remainder of the mediation?
I'm not sure if that's what we discussed at that point, but if it turns out that the insurance company is going to cover for this accident, then we would be, I'm guessing at that point, they would probably have their own counsel get involved and there's probably going to be another mediation in the future, Judge. But I issued some subpoenas out of this case for Fred Loya, and they have failed to respond as of yet. So I have to, and I was asking for the policy in its entirety, Judge, to see if their claim that the driver was an excluded driver. But I haven't gotten any responses from Fred Loya yet. So I need to see what else I need to do, either to bring them in or to force them to produce those documents to us, Judge.
Okay, well, how much time will you need for that? Because, I mean, there needs to be some type of resolution to that. So either they were covered, not covered. It's very simple.
Well, they've already issued a denial to previous counsel in regards to Mr. Cortez. But I still haven't, I don't have a copy of the policy, and I want to see, in black and white where the driver was excluded. And so the subpoena went out to them from this case requesting that policy for Mr. Cortez at the time of the accident, and they didn't respond. So I'm hoping maybe if the court can give us another 30 to 60 days, and I need to figure out what other steps I need to take, or do we have to bring in the insurance company through a counterclaim, something like that.
Okay. May 25th at 9:30. And please see what it is that can be done before then. Maybe you can tell Fred Loya that you're under the gun here with the court so that they need to do something or else you're going to take some adverse action.
Sure.
Okay, anything else?
That's all we have, Judge.
Oh, okay. Then you all are excused. You all have a good day.
Thank you,
Thanks,
Judge.
Judge. Have a good one.
Okay. All right. Mr. Clark, did you have another case? Okay. All right. Who's on iPhone with the hand up? With the raise your hand? Okay. All right, Mr. Alvarez, what do you have? Attorney Oscar Alvarez.
Your Honor, I represent the respondent in the case. Sergio Sanchez represents the petitioner. I filed a motion for mediation in the case and submitted 3 names to the petitioner. I submitted the names of Carlos Ochoa, Andrew Maguer, or Elvia Sainz as potential mediators. They suggested Savannah Gonzalez. So we got 3 people on the table. I ask Your Honor to appoint one of those 4 individuals to mediate this case. It is a contested case on conservatorship and all issues.
Okay, and is Miss Alvarez on? Do you see her anywhere? Brenda Alvarez, are you present? Go ahead and unmute, ma'am.
Yes,
Miss Alvarez, have you heard from your attorney?
I'm here at the office right now.
Okay, was he going to make an appearance?
Let me ask real quick. Hold on.
Okay.
He's gonna log in already.
Okay. Okay, let me just wait for him to log in, Mr. Alvarez, and I'll recall your case shortly as soon as he logs in.
Very well, Your Honor.
Okay, thank you. All right, Mr. Quintanilla, what do you have, sir?
Your Honor, good morning, Judge. I am on case number 24 on your docket, Your Honor.
Okay, CL 181247-I, Jesus Zuniga et al. Versus Adrian Garcia Chavez et al.
Yes, ma'am. I represent Mr. Garcia Chavez, Your Honor, and I believe that we are the sole remaining defendant, Your Honor. We came late into the game, but we're the only ones left. This is a multi-car accident that happened there in Palmview almost 6 years ago. Mr. Santos represents the plaintiffs. Now, before I got involved, Judge, a round of depots have been taken. All of Mr. Santos's clients have been deposed, and one of the co-defendants was deposed. So, plus the case was already mediated with Mr. Garza, your Bill Garza, Judge. But with that in mind, Your Honor, what I need, I just filed a motion to compel yesterday, Judge. I need a hearing on that motion for my discovery responses or Mr. Santos's client's discovery responses. And I believe that a mediation, perhaps within the next 45 days, given what we have already on the file, could be a fruitful thing for us to resolve this case, Judge.
Okay, Mr. Santos?
Good morning, Judge. Yes, for the record, Daniel Santos on behalf of the plaintiffs.
He's correct, I guess, for the most part, what he stated in terms of the history of the case. We did get the other portion of the case resolved. And I guess just kind of working backwards, I'm in agreement with the mediation. That helps move the case forward. If we can't get the case resolved, I know that gets us closer to the DCC. I've been listening to all the DCCs that have been filed and requested. And so I like the idea of the mediation because it keeps us on a clock or on a schedule. So I'm in agreement with that. As far as the motion compel, Judge, we received a letter yesterday on the discovery with these issues. In the letter, it indicated that he was waiting for a response, I believe by sometime of next week. I don't have the exact date. I'm sure he's got it there. If not, he would file a motion compel. 3 hours later, he files a motion compel. I think it's a little premature on this motion, but as I'm sure we can work out those discovery matters, I don't see it being an issue. And if there is, there's sufficient time to go ahead and get that. But I'm at the court's disposal, however you see
Okay,
fit.
so how much time do you think you'll need to submit the documents to comply with that motion?
I think he had about a week from yesterday, and this is a lot of. I suspect it's a lot of the same discovery. Somehow, this is one of those that slipped through the gaps on our end. But I don't think we need very much time. I mean, there's a week. If we got 2 weeks, that would be more than sufficient time to be able to get the necessary discovery in.
Your Honor, I would like counsel said, he's been at it longer than I have on this case, so I'm sure he can get me those responses. And the only reason that I acted quickly, Your Honor, is because we had this conference scheduled so we could report to the court, and I know the court wants to move things along quickly, and so do I, for that matter. I'm sure Mr. Santos as well. And only basically to kind of light a fire, if you will, Judge, all in an effort to try to get this thing mediated, hopefully within the next 45 days, if not sooner, Your Honor, so we can hopefully report to the court a successful outcome.
Okay, so why don't we do this? I'm going to go ahead and give Mr. Santos the 14 days that he is requesting. So then if he'll have until April the 15th to submit those discovery responses. If for some reason y'all have an issue and you don't receive the responses that you need by that date, Mr. Quintanilla, go ahead and contact us and we'll set your motion to compel.
Yes, Your Honor, I appreciate the judge. And again, just so the court can know, Mr. Santos and I have a very good working relationship. Obviously, I have some orders to follow here, Judge, as he knows. But at the end of the day, I will grant him any courtesy that is within my power to do so, Judge.
Okay, and then go ahead and return back to mediation when you're ready with Mr. Garza, since he's already familiar with the case. And he can help you hopefully conclude it. And we'll come back here on June the 27th at 9:30, unless you need a setting earlier.
Your Honor, the 27th of June is for another status hearing, Judge?
Yes.
Yes, ma'am.
Just to make sure that you all are still moving along.
And Judge, just so I understand as well for clarification, is it the court's order that we mediate before, I mean, the standing order that we mediate before June 27th?
Yes.
Okay.
Well, because y'all are saying that once you get that, then you can mediate within 45 days. So just go ahead and do that. And then we'll see where you all are at that time.
Okay.
Thank you, Your Honor. I appreciate that. Thank you, Counselor.
Thank you.
Okay. Anything else?
That's all I have on my end.
Okay.
Have a wonderful day, Your Honor. Thank you, Judge. Thank you,
Thank
Counselor.
you. Likewise. Okay. Ms. Alvarez, your attorney still hasn't come on and Mr. Alvarez has been waiting. Can you just make sure with them that he's getting on now?
Let me tell him right now.
Okay, thank you. All right, Ms. Sampson, I have a Ms. Sampson.
Good morning, Your Honor.
Good morning. What number?
I'm on docket number 26, and Eddie Trevino and Alberto Barbosa are opposing counsel appearing. We have the defendant, MMCTG, is represented by Carlos Izaguirre, who can't attend, but we've been in contact with him about this.
Okay, CL 190544-I, Edith Trevino versus MMCTG LLC et al.
Yes, Your Honor.
Okay, and go ahead, Mr. Barbosa, who do you represent?
Good morning, Judge Irais Duran and Edward Galindo.
Okay. And Mr. Trevino?
Good morning, Judge. I represent Edith Trevino. She's a plaintiff in this case.
Oh, okay. All right, and what is the announcement?
Your Honor, and for the record, I represent Sergio Salvierna and Crystal Leos. We, in this case, had an order compelling discovery just signed on March 21st. So to give the defendant time to answer discovery, and then for the parties to conduct potentially more discovery, I think we need at least a 60-day reset.
Okay.
And then we might be headed towards trial, which I know is going to be a long road.
Yeah.
From what I've heard in this court.
Okay, anything to add, gentlemen?
Judge, no, just for the record, I did talk to Carlos Izaguirre earlier, Judge. He apologizes. There was a mix-up in his office, but he has no objections to the 60-day reset, Judge. And we're also trying to work for a resolution in this case, so hopefully we can get that done.
Judge, my understanding was that we had reached or maybe had a partial agreement in this case. I'm not sure where we're at with that. But my client, on behalf of my client, very little or minimal discovery has been made. I don't think any depositions have occurred. So I was hoping to find out what since I was not present at the last mediation, I was hoping to find out what, if any agreement had been made.
Okay, well, I was definitely not present, so I can't tell you that. So you have to ask your colleagues here.
Mr. Trevino just got added to this case. The rest of us are growing impatient, which is why I think we're coming out on different opinions about this. But
Okay.
that is all to say, Your Honor, that I mean, you know,
okay,
some of us are keeping pressure, but we know that the court has a backlog of trial dates. So
yeah.
Well, we're aware.
Let's go ahead and do this. Let's come back on May the 25th and let's see if you all have made any kind of advancement.
Yes, Your Honor.
Thank you, Your Honor.
And that'll be May 25th at 9:30.
Thank you, Your Honor.
Okay, anything else?
No, Your Honor, may I be excused?
Yes, ma'am.
Thank you,
Thank
Judge.
you so much. Have a great day.
Thank you, likewise.
Thank you, Judge.
Okay, all right, Mr. Sanchez has logged in. Mr. Alvarez, so let me recall your case. That's F0298-22-9 in the matter of the marriage of Brenda Alvarez and Efrain Alvarez.
Judge, I suggested the three mediators in this case, Elvia Saenz, Andrew Almaguer, or Charlie Ochoa. I submitted that to Mr. Sanchez. And they submitted to me a name of Savannah Gonzalez. I've never mediated a case with Ms. Gonzalez. I have with Elvia and Andrew and Charlie, and I've been very successful in resolving cases with those three individuals. So I'd like for the court to appoint one of those four individuals to mediate our case, possibly recall that the mediation be conducted within 60 days, and we report back to the court.
Okay, so what's the main issue in this matter?
Judge, everything is an issue. Here, my client is requesting custody of two of the children, and two of the other two. There's four children involved. He wants custody of two children, and there's also issues regarding child support, dental support, division of property. So we need to mediate the whole case, Your Honor.
Okay, and what are the ages of the children? Ms. Alvarez, can you give me the ages of your children?
Yes, ma'am. It's 10, 12, 14, and 16.
Okay, and so he's asking for what? For custody of the two
My
oldest?
12-year-old. No, he wants the 16-year-old and he wants the 12-year-old, which is my three daughters are the smallest ones. But my daughters don't want to go with him.
Okay. All right, so what I'm gonna do, Mr. Sanchez, did you have anything that you wanted to add? Mr. Sanchez? Okay. I'm not sure why your attorney is not responding, Ms. Alvarez. But what I'm gonna do is I'm gonna appoint Marisa Carranza Hernandez. I'm not going with any of the ones that you all have suggested because we want to be able to get started in the spirit of neutrality. So if I pick one from one that's suggested or one of the other one, then you're already gonna start with, oh, they picked hers or they picked his. So we're gonna pick nobody's and we're gonna go with Marisa Carranza Hernandez. If you need her, I'll go ahead and ask my staff to prepare an order of referral of mediation for Ms. Hernandez for you to attend mediation with Ms. Hernandez. And she is very well versed in custodial issues and in property division. So we'll go ahead and do that. And then are you all still conducting discovery, Mr. Alvarez?
Judge, this case is very new. It's just 61 days on the docket.
Oh, okay.
We barely are getting into. I just got hired a week and a half ago on this.
Oh, got you. Okay, let's go ahead and do this. We'll do, since you all will be mediating this, we'll come back on May the 25th at 9:30 for a status. And if it's ready for final, we'll take it up for a final hearing at that time.
Very well, Your Honor.
May 25th at 9:30. Okay, Ms. Alvarez, if you can please let your attorney know, I'm not sure if he's having, but he's not responding, okay?
Okay, I will let him know.
All right, May 25th at 9:30.
Okay,
Thank you, Your Honor.
thank you.
All right, best
Have a
of
good day,
luck
Your
to
Honor.
you all, likewise.
Bye-bye.
Okay, Mr. McLaughlin, I know we have your default judgments. Let me just make sure that I don't have any other quick announcements before we get to that. Okay, Miss Luna, Cassandra Luna, what case are you here on? Can you please unmute yourself, Cassandra Luna?
I believe it's on number 13, Judge.
Hello?
Okay, Mr. McLaughlin, this is one of your cases. It's CO 170633-I Portfolio Recovery versus Cassandra Luna.
Yes, Your Honor.
Okay. And did you want an opportunity, Ms. Luna, to speak to plaintiff's counsel to try to make arrangements?
Yes, ma'am, please.
Okay, do you have something to write with?
Yes, I do.
Okay.
My phone number is 512
512
339
339
4100.
4100. I'm sorry, and your name?
Robert McLaughlin.
Robert. Thank you.
Okay, we'll return on this case on May 25th at 9:30. If it's been worked out before then just submit the paperwork and we won't have to have the hearing.
Okay, thank you, Your Honor.
Okay, did you need any information from her, sir?
Cell phone number, maybe?
No,
No? Okay.
I believe it's in the file.
Okay. Or an email address, Miss Luna, do you have an email address?
Yes, I do. It is CRLUNA89@gmail.
Okay.
All right, thank you.
Thank
Okay,
you.
Miss Luna, take care.
Thank you, ma'am.
Okay, let me see. Moto G Power right here, sir. I'm asking you to unmute. Okay, what's your name, sir?
Leonel de Leon.
Okay. And he's number 8 on your docket, Mr. McLaughlin. That's CL 184128-I, Portfolio Recovery versus Leonel De Leon. Mr. De Leon, do you want an opportunity to speak with plaintiff's counsel to try to make arrangements?
Yes,
Okay, do you have something to write with?
yes.
Okay, you need to contact Mr. McLaughlin at 512-339-4100.
Okay.
And do you have an email address?
Yes.
Okay, what is
Leo-
that?
Leonel DL 1988 at yahoo.com.
Okay. You'll return on May 25th at 9:30 to see if you've reached an agreement before then and the paperwork is in, you don't have to show up. But if not, then you'll come back on May 25th at 9:30.
Okay, thank you.
Okay, sir, you're excused.
Thank you.
Okay, Jorge Zamora. Jorge Zamora.
Yes, Your Honor.
Okay, what case are you here on, sir?
I am here on, well, cause F-3391-17-9.
Number 5.
Oh, okay.
Good morning, Your Honor. It's Bella Olivares. I'm Joaquin Zamora, is his attorney, I believe. Is that mine? And Rita Zamora? I'm on the
Yes,
iPhone.
ma'am. Yes, ma'am.
Okay. We have
Okay.
an announcement. If Joaquin is not on, Judge, he's at the dentist. He might be on already. I'm not sure.
Okay, well, he's logged in, but his screen is not on.
Okay, he's probably busy with a dentist. Judge, our announcement is that Ms. Zamora, Rita and I will be signing the decree. It's already been done, prepared, approved, and hopefully by Thursday, we all can sign the cars and properties because there's a lot of assets that we need to sign back and forth, and we can e-file our decree.
Good morning,
Okay.
Your Honor. Joaquin Zamora here for the respondent.
Oh,
Jorge Zamora,
there's
my
Joaquin.
apologies. I was in another court.
Oh, that's okay. All right, so Mr. Zamora, is that your understanding that decree will be signed by Ms. Olivares and her client by Thursday, and then you all will sign off on all the car titles and all of that?
Right, and also taking some photographs of the residents, tendered over the lease agreement that needs to be signed by the petitioner, and then, of course, ratify everything else that's on the final divorce decree.
Okay, so
That is correct, Your Honor.
how much time do y'all need to submit that decree then?
Assuming that her client, Ms. Olivares, and her client can sign off by tomorrow, no later than Friday morning.
Okay, I'm gonna go ahead and have a tickler set for April the 8th to make sure that it's been submitted by that date, okay?
Very good.
Thank you, Your Honor.
Thank you. Your Honor.
Okay, best of luck to y'all.
Thank you. Your Honor.
Thank you. You have a wonderful day.
Okay, thank you. Y'all are excused. Ms. Saldana, what case do you have? Go ahead.
Good morning, Judge. I have P011820-9 with Albert Osorio. I'm not sure if he's on yet.
I don't see him on.
Look, I can reach out to him to confirm what's the status on his client and some classes, if the court can recall this case shortly.
Sure, no problem.
Thank you, Judge.
Okay, who is on the phone?
Mark Roberts, Your Honor, on behalf of Bank of America.
Oh, okay. You only have one case, right, Mr. Roberts?
That's correct, Your Honor.
Okay, do you remember what number it is?
Your Honor, I am sorry. I did not get that. I apologize, Your Honor.
Oh.
I thought it was 9, but I don't think so.
Mm-mm. Let me check.
Do you need the cause number, Your Honor?
Oh, it's at 11. So you can log back in at 11. Since it's an agreed, there's an agreed judgment on file?
Yes, Your Honor. We just wanted to make sure the court was aware of that.
Oh, okay. Then don't worry about it.
Thank you so much, Your Honor.
Okay. Have a good day.
You too, Your Honor. Bye-bye.
Okay, let me see. Who's on the phone? Can you announce yourself? Okay, they hung up.
It's hereby granted. And CL Lawson.
Okay. Mr. Clark, did you have another announcement? I don't think Mr. Clark is on anything else, right? Okay, we'll go, now let's go ahead and get started with your cases, Mr. McLaughlin.
Okay, Your Honor.
Okay, now starting with number 7, correct?
Yes.
CO 172588-I Portfolio Recovery Associates versus Josefina Valderas. Josefina Valderas. Josefina Valderas. Okay, the name being called out 3 times and no response. You may proceed.
In this case, we believe that the defendant had opened up an academy credit card on October 1st of 2013, making their last payment on July 2nd of 2014. The account was closed and charged off with a balance of $2,295.57. We're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, somebody just logged in. Let me just go ahead and call out that name again. Josefina Valderas. Is that you, Josefina Valderas? Okay, that was not, the person is not responding. So the court is taking judicial notice of all the documents in the court's file. Specifically, the return of service that has been on file with the court for the required amount of time. There is no answer that has been filed on behalf of the defendant to date. Therefore, the court is granting the motion for default judgment, and it will sign the order that was e-filed with the court on October 23rd, 2019.
Thank you, Your Honor.
Okay, and then the next case is CL 181388-I Portfolio Recovery Associates versus Maria Espinosa, ESPINOSA. Maria Espinosa. Maria Espinosa. Okay, the name being called out 3 times and no response. You may proceed.
Yes, Your Honor. In this case, we believe that they had opened up a Synchrony Bank credit account in November of 2010, making their last payment on July 12th of 2016. The account was closed, charged off with a balance of $1,272.42. We're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records, non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. And that no answer to date has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and put on the record and set forth in further detail in an order filed with the court on May 6, 2020. Okay, CO 185887-I Portfolio Recovery Associates versus Maricruz Garcia. Maricruz Garcia. Maricruz Garcia. Name being called out 3 times and no response. You may proceed.
In this case, Your Honor, we believe that the defendant had opened up a Synchrony Bank JCPenney credit account on February 21st of 2007, making their last payment on October 23rd of 2015. The account was closed and charged off with a balance of $1,388.27. We're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. To date, no answer has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that was filed with the court on September 19, 2019. Okay, CL 175118-I, LVNV Funding LLC versus Ryan Hoover. Ryan Hoover. Okay, you may proceed.
In this case, we believe that the defendant had opened up a Credit One Bank credit account in December of 07, making their last payment on April 14th of 2016. The account was closed and charged off with a balance of $1,969.28. We're seeking that amount in damages plus costs of the court. Would ask the court to take notice of the business records, non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service. Let me see. Oh, there we go. Okay. They had it under a different category. Specifically, the return of service that has been on file with the court for the required amount of time. And no answer has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that was filed with the court on September 18th, 2019.
Your Honor, if I may.
Go ahead.
In going over the case, Judge, I was noticing that the defendant might have appeared in person when we were still pre-COVID. In the prior court, they set this case to be mediated by an attorney within 30 days. But I don't have any information just for the court's records, Judge.
I saw that, but I didn't see a note whether that was just an order of the court or if it's because the person showed up in person. Mr. McLaughlin, you may want to find out. Why don't we hold this over? And you may want to find out whether or not that person appeared in person and that's why it was submitted to mediation. But I have no note saying that except that it was to be mediated.
Okay.
So we'll go ahead and reset this. I'll give you a little bit of time to look for that in it. You can come back on May 4th at 9:30.
Okay.
All right, the next one is CL 170852-I, Portfolio Recovery Associates versus Rodolfo Lopez. That name being called out 3 times, no response, you may proceed.
In this case, Your Honor, we believe that they had opened up a Bell's credit account in April of 2013, making their last payment in May of 2014. The account was closed and charged off with a balance of $925.08. We're seeking that amount in damages plus costs to the court and would ask the court to take notice of the business records, non-military declaration, and certificate of last known address and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. And no answer has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that has been on file with the court since May 11, 2020. Okay. CL 154056-I, Portfolio Recovery Associates versus Mauricio Martinez. The name being called out 3 times and no response, you may proceed.
In this case, we believe that they had opened up a credit account in March of 2011, making their last payment on June 3rd of 2012. The account was closed and charged off with a balance of $3,184.75. We're seeking that amount in damages plus costs to the court I would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. There being no response filed on behalf of the defendant, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that has been on file with the court on November 7th, 2016. Okay, next is CL 164649-I, Portfolio Recovery Associates versus Robin, ROBIN, Rutledge, RUTLEDGE. Robin Rutledge, the name being called out 3 times and no response. You may proceed.
In this case, Your Honor, we believe that the defendant had opened up a Zales credit account in February of 2012, making their last payment in February of 2013. The account was closed and charged off with a balance of $1,516.42. We're seeking that amount in damages plus costs to the court and would ask the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested on the record by plaintiff and set forth in further detail in an order that has been filed with the court on May 4th, 2020. All right, CL 185329-I, Portfolio Recovery Associates versus Cruz, CRUZ, Tenorio, TENORIO, Cruz Tenorio. Okay, the name being called out 3 times and no response. You may proceed.
In this case, Your Honor, we believe that the defendant had opened up an American Eagle credit account in January of 2014, making their last payment on January 18th of 2017. The account was closed and charged off with a balance of $892.80. We're seeking that amount in damages plus costs to the court. We'll ask the court to take notice of the business records, non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. There has been no answer filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that has been on file with the court on January 10th, 2020. KCL 170167-I, TD Bank USA versus Jose Castro Valdez. Jose Castro Valdez, the name being called out 3 times and no response. You may proceed. Oh, Mr. McLaughlin, for some reason you're on mute now.
I'm sorry. In this case, we believe that the defendant had opened up a credit account on May 25th of 2013 with a last payment on April 20th of 2015, with the account being closed and charged off with a balance of $620.32. And we're asking the court to take notice of the business records, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. There is no answer on file on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order filed with the court on September 10th, 2019. Next case is CO 171869-I, Portfolio Recovery Associates versus Sherry, Sherry Vargas. Sherry Vargas. Okay, the name being called out 3 times and no response. You may proceed.
In this case, we believe the defendant had opened up a Bell's credit account, making their last payment on December 18th of 2013. The account was closed and charged off with a balance of $525.42. We're seeking that amount in damages plus cost of the court. Would ask the court to take notice of the business records, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. The court, there is no answer on file on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that has been on file with the court on January 22nd, 2020. And I believe that's it.
I have item 25 as well on the docket.
Okay, CO 196034-I, Crown Asset Management versus Dora Dibrell, Dibrell. Okay, and what is it's set for a status conference. I believe you needed an order setting hearing to be filed.
Yes, we need to have a setting for the motion for default judgment.
Okay.
And I will have an order setting hearing filed with the court.
Okay, perfect. Then we'll go ahead and file that order setting hearing. And I'm just gonna set a reminder for April the 8th.
Your Honor, if I may.
Go ahead.
Judge, I believe that she is on the phone, on the line with the numbers ending 100. She did contact the clerk's office, notifying them that she was having issues in regards to, I guess, unmuting herself on Zoom. So I'm not sure if it's her or it's not. What I can do is if she calls the clerks again, I'm gonna see if we can get an email for her. And I'll send that over to Mr. McLaughlin, if that's okay.
Okay, hold on real quick. Miss Dibrell, if you can hear me on your phone, click on *6.
Judge, this is Annette Muñiz with the Hidalgo County Clerk's Office.
Oh, okay.
Can you hear me?
Yes, ma'am.
Okay, so Ms. Dora Dibrell came into our office and she doesn't speak English, so she didn't understand the Zoom instructions. So that's why she came to us, but she is here in my office. Do you have any questions for her? She does not speak English.
Oh, okay. We have the translator here. I really appreciate you going this extra effort, Ms. Muñiz. Okay, if you want, you can put her on the phone and I'll have Ms. Castañeda ask her if she wants the phone number to try to get in touch with the company to make arrangements.
Okay, well, she's standing right here so she can hear.
Oh, okay, Ms. Castañeda, can you please ask her if she would like a phone number to make arrangements to on this case?
Señora, ¿quiere usted el número de teléfono para tratar de hacer arreglos en este caso?
Sí.
Yes.
Sí.
Okay, Mr. McLaughlin, is there a number for Spanish speakers?
I'll have to locate one.
Okay, instead, can we get her number and have you all contact her?
Yes, Your Honor.
Okay, Ms. Castañeda, please ask her for her phone number and let them know that Mr. McLaughlin's office is going to have their Spanish-speaking department contact them.
Señora Dibrell, por favor, me da su número de teléfono y alguien que hable español del departamento le va a llamar a usted.
Sí, gracias. 956-258-6405.
956-258-6405.
6405.
Yes.
Okay, let her know that the next her status hearing will be for May 25th at 9:30. Unless it settles and she signs the documents, then she won't have to appear on that day.
Ok, señora Diver, su próxima corte es el día 25 de mayo a las 9:30 de la mañana. A solo que lleguen a un arreglo y usted firma documentos que ya arreglaron el caso, entonces no tiene que aparecer. Si no, es la próxima corte es el 25 de mayo a las 9:30 de la mañana.
Muy bien, gracias. Se lo
Okay,
agradezco, gracias.
thank you.
Okay, and Ms. Castañeda, let her know that she can also go, if she goes to the courthouse because she has problems with the Zoom, that she can go to our office and we will set her up on the public access laptop.
Miss Dibrel, a la próxima vez si tiene problemas con conectarse con la corte por video, por Zoom, tenemos una computadora que es para el público en la oficina de la corte de nosotros. Puede ir al tercer piso y ahí la podemos ayudar.
Muchas gracias, que no sabía. Andaba vuelta y
Thank you, I
vuelta.
didn't know.
Okay, tell her that
Gracias.
that's fine and that she is excused.
Okay, ya se puede retirar, Miss Dibrel.
Sí, gracias, qué amable, gracias. Thank you, Judge.
Yes, thank you for your assistance.
Yes, ma'am.
Okay, anything else?
No, Your Honor, that's all I have. May I be excused.
You certainly may. Thank you, Mr. McLaughlin. Have a good day.
You too, Your Honor.
Okay, Ms. Saldana, were you able to get a hold of Mr. Osorio?
Yes, Judge, I was, and we are in agreement for a 60-day reset. He's going to be reaching out to his client to see where he's at with the bid classes.
Okay, P0118-20-9. So the 60-day reset will be granted. Will there be an extension filed then?
Yes, Judge, I can go ahead and get that e-filed, and then I don't know, I'm sure if you want to give me the date now, or I guess Bianca can fill it in.
May 25th at 9:30.
May 25th. Okay, Judge, thank you very much. That's all I have. May I be excused?
You certainly may. Thank you, ma'am. Okay. Mr. Cisneros, on your case, Mr. Sabo is on the other side, correct?
Yes, ma'am.
Okay, so he said he would log back in at 11, so it's a little early. So as soon as he gets back on, we'll go ahead and take you up.
Thank you, Judge.
Okay, Ms. Salina Cerda, is Mr. Kosofsky arguing the other side?
Yes, Your Honor, and we had filed a Rule 11 for the motion to strike, and we had come to an agreement in regards to that. I think that it's on file with the court. And the only thing we were gonna have, I guess, for today was a status, which was just to let the court know that we're still in the discovery phase.
Okay. And Mr. Begum, you're here on which case?
Sorry, Judge, I'm gonna unmute myself here. I'm here on the same case Mr. Cisneros is on.
Oh, okay. All right. So then, Ms. Salina Cerda, since you're here on you're just giving us a status, the discovery, you're in the discovery phase still. Have you all come up with a date for mediation or not yet?
No, Your Honor, we're still, we have the plaintiff's depot scheduled for, I think, late April. So we still have a ways to go.
Okay, so then do you think that you would have something productive by June 27th or more like August?
Maybe if the court is inclined, we could have a status in late June to see where we're at, and it's up to the court's discretion, Your Honor.
Well, I mean, it's fine if you're going to still continue with the discovery phase, and as long as you're working it, you can come back on August the 22nd.
Okay, Your Honor. Very well.
It's that sometimes I give a date that far and then they wait to start doing something till closer. I mean, I remember what it was to be on the other side, so.
Very well.
So August 22nd at 9:30.
Very well, Your Honor. For a status?
Yes.
Very well, Your Honor. Thank you so much. May I be excused?
You certainly may.
Thank you.
Okay, Mr. Sabo?
Yes.
Okay. So we'll go, and let me just wait for Mr. Cisneros to come back on the screen. Oh, there he is. Okay. Are we ready to proceed?
Sure.
Okay, let me call CL 183144-I, Alejandra Garcia versus Gilberto Beltran. Announcements?
Judge, defendant is ready to proceed on our motion to reconsider our motion to compel.
Okay, Mr. Cisneros, can you please just announce yourself for the record?
Yes, Your Honor. Mario Cisneros on behalf of the plaintiff Alejandra Garcia, and we're ready to proceed with this morning's hearing.
Alexander Begum for the same plaintiff, Your Honor.
Okay, Mr. Sabo, you may proceed.
Judge, this is our motion to compel, or our motion to reconsider the motion to compel based on the K&L Auto Crushers case, which the Texas Supreme Court wrote back in, I think, May of last year. The motion to compel is in regards to a request for production for, let me back up. The plaintiff in this lawsuit, Alejandra Garcia, was involved in a prior accident in 2014 and treated with two of the exact same providers that she treated with following the accident, which is the subject of our lawsuit. That we've got the bills, they were produced by plaintiff's counsel, and the treatment was virtually identical to the treatment following our accident. That case settled, and presumably the providers were paid at the end of that lawsuit. What we are seeking is the amount that the providers were paid, because the K&L Auto Crushers case holds that information about how much a provider receives in payment from others that have nothing to do with a particular party to a lawsuit is discoverable. And in that case, the Supreme Court permitted discovery from third parties of that information. We have a lot less intrusive of a request in this case. We're not seeking it from a third party, which the courts are inclined to protect a little more than actual parties. We're seeking it from the party herself. And what we're seeking is the amount she, not other people, paid, but the amount this particular party paid to these exact same providers. The request was admittedly a little broad, and I have agreed in my motion to narrow the request to documents reflecting the amounts paid by or on behalf of plaintiff for the medical services provided to plaintiff by Kit Chiropractic and Wellness Center and Insight Diagnostic and Imaging Center following the accident that plaintiff was involved in June of 2014. Those are the two providers that are similar in the two cases. And Judge, we've had a virtually identical motion a couple of months ago, I think it was, with another plaintiff counsel, exact same issue. And this court ordered the production of the documents, and the documents that I received were the checks. In that case, just like in this case, in the prior lawsuit, the plaintiff was represented by the exact same lawyer. Just like in this lawsuit, Mr. Begum and I don't know if Mr. Cisneros, but their law firm also represented the plaintiff in the prior lawsuit. So the checks were written by their office. So in that case, they produced the check, a copy of the check, reflecting how much was paid to, not even reflecting, it is how much it was paid. It was the actual document paying it, the bill. I will further narrow the request that I'm making in this case to a copy of the checks. So there'll be presumably two checks, one written to Kit Chiropractic and Wellness Center and one written to Insight Diagnostic and Imaging Center for the, resolution of the bill from the prior lawsuit. So I'm limiting the request on the record to those 2 checks. And I think that's clearly within what is contemplated, is required to be produced, and is clearly relevant in accordance with the Texas Supreme Court decision in the auto crushers case. Plaintiff, I don't know if you have the plaintiff's response, Judge. It was filed yesterday late. I saw it last night for the first time. I don't know if you've got it, but I want to address each of the arguments made by plaintiff's counsel in their response. They have, I think it goes to F, whatever that is, 6 points. The first one is that auto crushers does not stand for the proposition that reimbursement rates are admissible. I'm not really sure what that has to do with this case at this time, because we're not talking about admissibility at this point. We're talking about whether it's discoverable, which auto crushers clearly says it is. They, in that same argument, they say, and auto crushers does not stand for the proposition that settlement breakdowns are discoverable. Again, that's not an argument in this case, because in what I've now stated is our more narrowly tailored request, we're not asking for that. We're not asking for the settlement statement or any other breakdown. All we're asking for are the checks that were paid to the providers. There's argument about confusing admissibility with discoverability, and that really is irrelevant because this is not an admissibility issue at this point. It's discoverability, which clearly it is. Plaintiff then in that same section makes up the point that we're requesting documents dated 8 years ago. The math is a little off. It's actually closer to 6 years ago, and it's closer in time. I mean, the documents, the treatment, our accident was in 2017. The prior accident was in 2014, and the treatment was in 2015. So it's a very short period of time after, between the 2 accidents. So the amounts paid in 2014, 15, 16, whenever the payment was made, clearly relevant to the scope, the time frame of 2017 when this accident happened and the second round of treatment occurred. Second argument is that the requested information is not relevant. That's specifically addressed in the auto crushers case, and is auto crushers makes it very clear that the amount received in payment is relevant to the issue of reasonableness of medical charges, which is the issue in this case. Third argument is that the documents sought would violate attorney-client communication privilege and work product privilege. It's a check. We're narrowing the request to a check. So that's irrelevant. I think that the fact that we've narrowed it to a check or 2 checks satisfies that issue, that there's no attorney-client work product privilege for a check. So that entire section is not applicable. The fourth point made by plaintiff's counsel is very concerning to me, Judge. And that point that they make is the documents sought no longer exist. And I think that's very curious. And the reason they say it doesn't exist is because their law firm has a retention policy of 4 years, and I guess is claiming that those documents were destroyed after that 4 years. You still there, Judge?
Go ahead, Mr. Sable,
Oh,
I'm listening. I'm just
Sorry,
grabbing
sorry, the
no,
screen.
I'm listening. I'm just grabbing a pad. I
And
ran out of paper on the other one.
Judge, the reason that the argument that the documents have been destroyed in accordance with our retention policy is very concerning to me. The request for production of these documents was made back in 2019. And in response to the request for production, which was done in December of 2019, obviously plaintiff objected, but they did produce the medical records and bills for the plaintiff from the prior lawsuit, which is curious to me because obviously the file hadn't been destroyed at that point in time because they had documents to produce that would only have been in the file. So documents were produced from the file, and after having received a request for specific documents, the concerning part is plaintiff's counsel knew this was an issue. They knew there was a request for documents relating to the payments made. However, at some point after the production of the selected documents from the file that didn't address what we were asking for completely, they then took it upon themselves apparently to destroy the remainder of the file, which is what their argument is, their fourth argument as to why they're not available. I find that baffling and very concerning that after a request for production is made, they have objected to some of the information that they know we're seeking and then destroyed those documents and are claiming they're no longer available, which is, I mean, the ethical issues raised by that are numerous, but it's very concerning to me, Judge. However, we can avoid all that because all we want is a check, the two checks. They can get that from their bank. And I will offer on the record, if they request the checks from their bank and get the copies of the checks and produce them and send me an invoice from the bank that shows how much they were charged for getting the checks to produce, we will agree to reimburse that amount to plaintiff's counsel for obtaining the checks reflecting the payments that were made that are at issue in this case. The fifth point made by plaintiff's counsel is that production of the documents would violate trade secrets held by counsel. I don't know where that comes from. All we're asking for is a copy of the check. So I think that concern has been alleviated by the fact that we're only seeking a copy of the checks. The last issue is virtually the same. Documents would divulge confidential settlement details. I mean, I don't think an agreement between plaintiff's counsel and treating doctors is a secret, or shouldn't be. So that really doesn't have anything to do with anything either, particularly since we've now limited our request to only a copy of the checks. So those were the points made by plaintiff counsel, and one of them is very concerning. Many of them are irrelevant now. So we're asking that plaintiff be required to obtain from her lawyer a copy of the checks that reflect the payments made to KIT Chiropractic and Wellness Center and to Insight Diagnostic and Imaging Center following the accident that plaintiff was, or regarding the treatment that plaintiff received following the accident she was involved in June of 2014.
Okay, Mr. Cisneros?
Well, Judge, before jumping into as to how K&L Auto Crushers is different from this case, I just want to point something out to the court, Judge. The plaintiff's prior case settled sometime in 2015, Judge. And Mr. Sabo can correct me if I'm wrong, but he sent over discovery requests to the plaintiff, Judge, not to my law firm, but to the plaintiff, seeking documents that are now almost 7 years old, Judge. My client is not in possession of any of this information, Judge. These requests were sent to the plaintiff. She signed an affidavit stating that she's not in possession of the documents. And, you know, she can't be forced to produce something that she simply does not have possession of, Judge. But over and beyond all those things, Judge, I think Mr. Sabo leaves out a lot of key details about auto crushers, Judge. Now, let me start off by mentioning that auto crushers involve discovery requests that were sent over to third-party medical providers. And what the defense firm sought in that, Judge, were contractual reimbursement rates and charge master data. That's important, Judge, because they were seeking contractual agreements that doctors had made with certain insurance companies. In this case, Mr. Sabo is seeking agreements that were entered into with doctors almost, 3 years after the treatment she received for this crash, Judge. It's not the same thing, Judge. And specifically, Your Honor, if the court will allow me to share my screen, I want to point some language out in that court from that case, Judge. I'd like to point it out before the court.
Okay, hold on. Go ahead.
Okay. And this is a portion of my brief, and this is directly from the case law, Judge. This is what the Supreme Court of Texas stated, Your Honor. The court held the negotiated rates the providers charge to private insurers and public payers for the medical services and devices provided to the plaintiff, which was Walker in this case, and the cost the providers incurred to provide those services and devices are at least relevant to whether the charge master rates the providers bill to Walker for the same services are reasonable. The court goes on to clarify, Judge, although we conclude that these types of information are relevant under North Cyprus, we did not hold then and we do not hold now that all communications or all documents regarding those topics are automatically discoverable, nor does our holding entitle a party to discover all evidence tangentially related to these types of information. Proportionality must control the extent to which a trial court orders such relevant information discoverable. Ultimately, Judge, the Supreme Court held that the charge master data and the reimbursement rates that these medical providers were paying to the insurers was discoverable only for the year in which the treatment was provided. So in other words, this particular plaintiff may have received treatment, for example, in 2019. The Supreme Court held that only the data for the charge master and the reimbursement rates for that specific year would be reasonable in terms of discoverability. Mr. Sabo is asking this court to order the production of checks dated sometime in 2015 with regard to treatment that was provided in 2017 and 2018. That squarely falls outside of auto crushers, Judge. He's wanting to go back 3 years in time when auto crushers and the Supreme Court held that only the year in which the treatment was provided was discoverable. Moreover, Judge, as you can see from the case law, Judge, the court was very careful to note that all communications documents were not automatically discoverable, Judge. Here, Mr. Sabo, he changes his tunes from settlement breakdowns to checks, but the case law is clear, Judge. Not everything is discoverable just because it involves a lawsuit, And I think the reason that Mr. Sabo wants these documents is because he's getting ready, Your Honor, to make the argument that these documents should be admissible. But Auto Crushers doesn't speak to that. Auto Crushers does not speak to admissibility, Your Honor. And there's nothing within the opinion, Your Honor, there's not one sentence that states that settlement breakdowns checks are somehow discoverable. This court has already ruled a year ago, Judge, that these documents were protected by the work product and the attorney-client privilege, Your Honor. Moreover, Judge, there's a long list of cases state, Your Honor, that reimbursement rates are not admissible. I set them forth in my brief, Your Honor. There's a long list of federal court opinions stating that reimbursement rates are not admissible. The jury doesn't get to hear about them, and in most cases, they aren't even relevant, Judge. And, you know, I'd like to reassert to the court that in this particular instance, Your Honor, while Mr. Sabo has changed his tune from settlement breakdowns to settlement checks, the fact of the matter doesn't change, Your Honor, that those communications with those doctors was made within the facilitation of legal services, which still subjects those documents to the attorney-client privilege, Your Honor. Mr. Sabo also fails to mention, Your Honor, that there's also a long list of cases within the Supreme Court jurisprudence that hold that billing statements and things of that nature are protected by the work product privilege, Your Honor. And there's also a case out of Houston, Your Honor, that I cite in my brief that states that settlement disbursements are irrelevant when they have no bearing to the case at hand. And in this particular instance, Your Honor, the settlement breakdown or the checks from 2014 have no bearing on what the plaintiff was billed in 2017 and 2018. As we've seen over the course of the last year, Your Honor, prices change over time, inflation sets in, cost of living goes up. There is nothing related to the treatment in terms of cost from 2017 that relates back to 2014. There is just no relationship, Judge. Every case is different. Every plaintiff is different. Every medical condition is different. And for him to say that there's somehow overlap is just incorrect, Your Honor. Moreover, Your Honor, if he is allowed to discover these checks and if he is allowed to produce them to the jury, what we're going to end up having to do, Your Honor, is we're going to have to try a case within a case. We're going to have to explain to the jury why the doctor was paid a certain amount back in 2015 versus what the doctor is owed currently, Judge. And that just does not comport with the rules of discovery and with the case law that states that settlement breakdowns and attorney's fees are not discoverable and are irrelevant, Judge. And just one last thing, Your Honor, and I think what Mr. Sabo fails to realize is that with regard to what we may or may not have paid the doctors back in 2014 has no bearing in this case, Judge, because every case is different. In some cases, you know, you may have a hospital bill for $45,000 and you may have some additional treatment. However, you know, there may be just $30,000 worth of insurance money, Judge. So therefore, your reductions are going to have to be more substantial with respect to each individual facility because the bills are more than what is being offered by the insurance company, Judge. And that goes to the crux of Mr. Sabo's argument. He wants to say that we have some sort of contractual relationship with these doctors, and that's just simply not the case, Judge. Every case is different, Your Honor. Different cases require different reductions, and Mr. Sabo knows this, Judge. And to sit here and say that auto crushers, which discuss contractual relationships between doctors and insurance payers should apply to this case is just simply incorrect, Your Honor. And for those reasons, Your Honor, over and beyond these documents no longer be in existence, Your Honor, we would ask that the court deny Mr. Sabo's motion and not go back on the order that this court entered into back in May of last year, Judge.
And Judge, I just have a couple of comments that I think are
one horse, one jockey, Alex, is what I understand the rules to be.
Well, I mean, if that's what the judge wants, if she doesn't want me to make comments, I'm fine with that. Frank, I don't think it's your call.
Well, it's just going to be argument. If you want to add something, I'll give you an opportunity to confer with Mr. Cisneros.
Oh, it's
If you
fine.
want,
If, I mean, when opposing counsel attacks, raises ethics issues, I think it's incumbent upon the owner of the firm to chime in, but.
Destroying documents is an ethics
Well, first
issue.
of all, nothing was destroyed. The original order denying your request was over a year ago. I could have just, if we would have gotten rid of them the day after, there would have been nothing unethical about it because you were already precluded from getting those documents. And so you forgot to mention that. These are discovery requests that are specifically for the client, Your Honor. And the client does not have these documents in their possession. But aside from that, this idea that he wants to compare the payments that were made to a provider on a case that is completely different from this case, K&L Auto Crushers, which is really the only new case he cites. All these other arguments that he brought up are brand new. I mean, are not new. He's already argued these to the court. They'd already been denied. K&L Auto Crushers does not talk about the kind of discovery that he's seeking. That would be opening up, blowing the doors wide open on K&L. And where does it stop? I mean, you really want to be issuing orders, Your Honor, for law firms to turn over attorney-client privilege on previous cases they've done? Because I guarantee you, this order gets out that's what's being allowed in Hidalgo County. Insurance defense lawyers like Mr. Sabo are going to be pursuing those left and right. And this is invasive discovery against law firms. There's really no relevance to it. It would never be admissible. And that is something you have to weigh is this evidence that's going to eventually make it to the admissibility stage. And because there is absolutely no way that a separate case, what was paid to a physician on one particular client years ago, is ever admissible, I don't see how it's relevant to discovery. And the client does not have them in their possession.
Judge, the discovery rule isn't simply possession, it's also control. It is clearly, it's her lawyer, her case, both times. Possession, custody, or control. She certainly has a whole lot more control over those documents than anyone on the defense side. They are her lawyers, and she can tell her lawyers, I want the piece of paper from my prior lawsuit. I need that check. So to say that it's not in her possession is, let's just call it ignoring the remainder of the rules regarding discovery that add or custody or control, which in this case they have. So it's clearly within her possession, custody, or control.
So when you get your medical defense experts and I ask for all payments you've made to them and they tell me they don't have them, I can now start asking the court for you to produce every single check you've ever made to that defense expert. I mean, Judge, that's the kind of invasive discovery you're asking for, is
Judge,
against law firms and lawyers.
In discussing, Mr. Cisneros pointed out a provision in the Auto Crushers case I think is very important to actually take another hard look at. It's the one that was read by Mr. Cisneros. It says, what is discoverable is the negotiated rates the providers charged to private insurers and public payers.
That's Medicare, Medicaid, Frank.
That's
what a public payer is. Medicare, Medicaid, by definition, in the K&L Auto Crushers.
The plaintiff is a public payer. It's effectively a cash payment to the provider. We are entitled to know what the amount paid, the negotiated rate would be what they ultimately paid, is the negotiated rate to determine whether or not the amount charged in this case is reasonable. We're entitled to a whole lot of information regarding how much the provider is paid for the service that is similar to the service provided to the plaintiff. In this case, we've got the same provider, the same service, the same lawyer, and a payment made for a bill, and we are entitled to know how much that negotiated rate charged to the plaintiff through her lawyer was. That's what the Auto Crushers case says, very simply.
And Your Honor, but Auto Crushers only goes back a year. Mr. Sabo is wanting us to go back 8 years in time, Judge.
It's not 8 years, number one.
Well, I'm
The
sorry.
difference,
Three years in time, Frank. You want
the
us to go
time
back
of the
3 years in time? Auto
difference
Crushers was
between-
a
Hold
year.
on, guys, gentlemen,
It's,
one at a time, because we're trying to make a clear record, okay? So Mr. Sabo right now is talking, and then I'll let Mr. Cisneros respond.
just we're looking at it a little over. It's right around 2 years between the. Well, I don't know when the payment was made to the providers. I don't know when that was. The two accidents are a little over 2 years apart from each other. The treatment for the second one was in 2017, and I think the treatment for the other one was in 2015, and the payment they say was made in 2015. I don't know. It may have been 2016. And one point Mr. Cisneros made was prices change over time. Exactly. Prices change over time, and I'm sure there may be a distinction in the prices, but the percentage of the bill is still the same thing. We can do math so that we have an understanding of what the discovery reflects is a reasonable charge, which would be if you took this last time, isn't that now reasonable this time? That's just basically where we're at, Judge. My experts, I'm entitled to have that information looked at by an expert. I mean, we're also not done. I mean, we also are entitled under Auto Crushers to seek this information from the provider themselves, much more and broader information. In this particular, much less intrusive form of discovery, all we're seeking is information relating to this particular plaintiff, same person, same provider last time. And, again, I think, in the last case that we did this, the check was produced, the two checks. In that case, were also two, and that was adequate. I think that provided the information that we're seeking, and that's all we're seeking in this case. And again, if the file in fact was destroyed, that any bank, that's easy, that's simple, a phone call, and they can get the documents from the bank, and we've agreed to reimburse any fee that the bank might charge for that.
Judge, and he's still leaving out the fact that Auto Crushers, the Supreme Court ordered the production of charge master data for the year the treatment was rendered, Judge. Mr. Sabo is still asking this court to expand that ruling, Judge. He's asking this court to blow the door open on it and order a much more intrusive type of discovery. And like Mr. Biga mentioned, Your Honor, what this is going to end up doing is defense attorneys like Mr. Sabo sending these sorts of requests to law firms and banks. And I don't think that's what the Supreme Court envisioned when they handed down Auto Crushers, Your Honor. They ordered the production of contractual agreements between insurance companies and doctors. That's not what Mr. Sabo is seeking in this case, Your Honor. We have no contractual agreements with these doctors. And as I pointed out, every single solitary case is different. Some cases require greater reductions than others, Your Honor. Obviously, in a case where we get a much larger settlement with fewer bills, we may not need reductions, Your Honor. And that's what Mr. Sabo is leaving out, Judge. We don't have contractual agreements with these doctors. So when he throws out percentages, Your Honor, that's a red herring for the court, Your Honor. because that doesn't necessarily apply in every single case, Judge. That's not what Auto Crushers says, Judge. Auto Crushers ordered the production of records with respect to the year in which the treatment was rendered. Mr. Sabo is wanting to discover rates of payments made in 2015 for treatment that was rendered in 2017 and 2018. That is simply not what Auto Crushers said, Judge. He is misconstruing the ruling, Your Honor, and I would challenge him to show you where the Supreme Court says that that type of discovery is proportionate, or that they're condoning that sort of discovery, Your Honor.
Judge, I will say this, although I know you've heard this argument from me now twice in a very short period of time, it's a very unique situation. It's not real often that that we have this exact same person going to the exact same provider for the exact same service for either a fairly recently prior or fairly recently subsequent incident that's now settled and that payments were made. So this isn't some huge explosion of cases opening up. It's a pretty unusual and unique situation in this case that we have that. I know you've seen too, but it's not common. I think those two are, out of all the cases I have, are it. They just happen to both be in your court.
So Judge, every time that any plaintiff has ever been in a crash, they can go back to the lawyer 8 years, 5 years, even if the same lawyer is not representing the same client. And now they're going to go through invasive discovery from law firms' bank accounts. I mean, that's really what you're saying here, if this is allowed. Moreover, again, K&L specifically talks about, this is the whole purpose behind K&L allowing reimbursement contracts. It's because those can be used to determine whether or not a charge is reasonable. But trying to say that a one-off case that may have resulted in a low settlement because of low policy limits relative to the bills, having had drastic reductions needed, as an example, from a particular provider, that doesn't go to show what a reasonable rate is, because it's not a contractual rate. K&L is very limited to contractual rates. If you read K&L, that is all it says. I haven't seen Mr. Sable present you one single appellate court case or any other case that says that this type of discovery is allowed. It just is not. It's not we don't have, if I had a contractual contract, if I had a contract, my law firm, or if my client had a contract with this particular provider about what the reimbursement was going to be, then I believe it becomes relevant and discoverable under K&L, because now you have a contractual rate that may go to show if the charge is reasonable. But there is no contractual contract about what is going to be paid to the physician. And he is confusing both. They're two completely different things. What a provider has to take because of limitations on coverage, because of liability issues, because the crash wasn't very much, because the plaintiff had other pre-existing issues that may drive the settlement value lower. There's 100 factors that come into why the doctor took less money on one particular case. But that does not mean that the doctor has a contract for a reimbursement rate. That's all K&L allows, is contractual reimbursement rates. It's not a complicated case. That's all it says. And Mr. Sable is trying to say that it says something else, or that you get bank checks and all this other stuff is way outside of the realm.
Judge, one thing that I also think I would be entitled to, if I were to send a third-party deposition on written questions with a request for production of documents to KIT or to Insight, the two providers at issue in this case, and I requested from them all of redacting, of course, confidential patient names and information like that. And I asked for from them all of the bills and all of the payments on those bills for clients of the Begum Law Firm. If I did that under K&L Auto Crushers, I would be entitled to that information from the provider.
That's not what K&L says, and that's not before
I
the court,
would
so
be
good luck with that.
entitled to that from the provider.
That's not what K&L
Because
says.
that's
Okay,
because
hold on.
that's a negotiated rate that
That
is
is-
paid. So I would be entitled to that. I'm not
Okay,
seeking
look,
that.
hold
My
on.
request is very narrow.
All right, so I've been very generous with the time that I've allotted to both sides, okay? And the thing is, and I understand what you're saying, Mr. Begum, that, you know, that they're gonna look at me and the court, but I'm gonna tell you something. It also stems from Mr. Sabo's correct. There was a case very similar to this in my court, and the attorney agreed to give him those checks. So if you're not, you know, it also has to be that you all need to collaborate with your colleagues. And it's kind of like if one falls, they all fall.
No,
And
I-
that, you
but
know,
that's different,
I'm just
Judge.
saying,
I mean,
I'm just
I can't
saying,
control another
I
lawyer.
understand, hold
agreeing
on,
to
I'm
something.
understanding that. What I'm saying is that it's not just on me. I'm just saying that when there's an attorney that ends up agreeing to that, well, of course, the defense counsel is going to see, well, that's a door that was open. Maybe I can open it with others. That's all I'm going to say with respect to that. However, I am taking all your arguments into consideration. I am not going to be taking, to me, whatever allegations are being thrown around with respect to getting, you know, prematurely getting rid of a file, or whether it was ethical, not ethical, that's outside of the scope of what we're here for today. So I'm not even going to address that or look at that or anything. I'm simply going to look at what this motion is about. And obviously, Mr. Sabo has agreed to limit it to those two checks. You all have declined to give him copies of those two checks, and that's fine. So what I'm going to do is I'm going to take all of this under advisement. I'll issue a ruling, just like I, you know, have with y'all in the past, and I'll look at everything. But what I'm saying is that the reason that defense attorneys think that they have this leeway is because there are some plaintiffs' attorneys that have given into that and given those checks. So I'm not saying that's what's going to happen in this case, but that's why, of course, if someone sees the door a little open, they're going to try to open it all the way and kick it down. So, but anyway, and obviously you don't have any control over your colleagues, but I mean, talk in the circles and, you know, is what I'm saying is you've got to stand together on something, because if not, the defense attorneys are also going to stand together on certain things. But anyway, it's a case-by-case basis. I don't judge it on anything else that has happened in other cases. This is the case that's in front of me, so I'm going to look at what's in front of me. So like I said, I'm going to look at everything. I'll take it under advisement, and then I'll issue a ruling. Okay, are your competing orders on file?
I believe we filed ours yesterday, Judge.
Okay.
If it's not, I will submit one, Judge.
I think I saw yours, Mr. Sabo. I'm not sure if I saw Mr. Cisneros'.
I don't think Mr. Sables was limited to what he's asking for now, but.
No, that's the thing is I think it was according to, you would need to submit a new order as to what it is that you're asking for now. I don't believe the order you have on file limits it.
I'll submit an order that tracks the language of the order that you signed on that other case, Judge.
So, okay, so go ahead and file those competing orders, and then I'll have Ms. Rivera look for them, and then she'll forward them to my queue.
Thank you, Judge.
Okay.
Thank you, Judge. Appreciate
All
your
right,
time
thank
tonight.
you. Y'all have a good day.
You too, Judge.
Thank you.
Okay, the only case we had left was number 6, CL196366-I, Mireya, Mirella, Alanis, Alanis, Flores versus Edinburgh Regional Medical Center. Did anybody call in on that?
Your Honor, not with Not with the court, Judge. I don't see anything on file. I'm sorry, I misspoke, Your Honor.
Okay.
They did file a Rule 11. It was signed by both parties without an order resetting. They've agreed to pass it, Judge, and that an order resetting would be filed later. They do have trial dates for the fall.
Oh, okay.
Okay.
All right.